Hi guys, you're welcome to today's edition of ABC of Company Law with Ori David. And in today's edition, I shall be expounding on the concept of limited liability. And in doing this, I've drafted 4 questions that would assist us and also enable us to have a full, detailed and comprehensive analysis of this concept. These questions are: first, what is limited liability? Second, how can a company become a limited liability company? Third, what is the legal significance of limited liability? Then fourth and last, how can creditors dealing with a limited liability company protect themselves? And without further ado, I shall attempt to provide answers to these questions in seriety. To the first question, what is limited liability? In an attempt to answer this question, it is pertinent to bring to your attention and also to lay the foundation that limited liability may be seen as the legal consequence of incorporation, which means that ordinarily, when a company has been incorporated, that is, when a company has been registered, the company automatically has its own legal, or what we call separate legal personality. So which means the company is seen as a persona in law, an artificial person in law, and the company has a destiny that is different and separate from the destiny of the members, meaning that what the company exists and the court or the law recognizes the existence of the company the same way the company also the law also recognizes the existence of the members of the company, such that there are 2 different entities. So when anyone is dealing with a company, the law takes it that you are dealing with the company, and in the event that you have claims that are to be satisfied in relation to your relationship with the company, then you look to the company's assets for the satisfaction of your claims, and not the asset of the members. And anyone dealing with the members on personal grounds would also have to look to the assets of the members, not that of the company, when dealing with what the members on personal ground. So when we begin to speak of limited liability, it then talks about the fact that when members decide, or when persons decide to set up a company, one of the things that must be decided is whether they want their assets and liabilities to be fused with the company in such a way that, aside their contribution to the company, they want a situation whereby if the company, say the company is in debt, or the company has any obligation towards outsiders, but then you find out that what the assets of the company cannot be enough to satisfy these claims, the question is whether the outsiders can turn to the private assets of the members of the company in satisfying their claims. So in order to protect themselves, you find that what these persons would then create or set up a company with a limited liability. So the idea of limited liability is to say that the liability of the shareholders, or the liabilities of the guarantors, that is in the event the company is one limited by guarantee, and their liability would then be limited only to the extent of their contribution to the company, or only to the extent of their commitments to contribute to the company. And there is a need to bear out that distinction between the liability being limited to the extent of their contribution and their liabilities being limited to the extent of their commitment to contribute certain amount. Yes, there is a need to bear out this distinction because it reinforces the difference between a company limited by shares and a company limited by guarantee. For a company limited by shares, it means that when a member purchases what shares, the shares would have monetary value. So he's supposed to pay so amount of money. Say he's supposed to pay 200,000. Like I already noted in my earlier video, and the law does not mandate that he pays everything at once. So which means that at times the company can ask him to pay at about 100,000 naira. So that is paid up capital, while the remaining 100,000 naira would be received later when the company will call up the capital, that is call up capital. So in the event that the company says liquidates, and you find that what the assets of the company have been valued, and company law says that when a company liquidates, the very first set of persons that are to be paid should be the creditors. So if there should be any money left after the claims of the creditors have been satisfied, then the money can now be returned to the members, that is the shareholders, by way of what we call return of capital. But that is not our concern. Our concern actually deals with a situation where after the asset of the company have been valued, and we find that what it cannot satisfy the claim of the creditors. So let's say the company is worth 500 million naira, but then they are owing at about, say, 700 million naira. So which means that if, as far as we're talking about the money from the company, it can only pay our creditors up to the tune of 500 million naira. So what about the 200 million naira remaining? Where will the creditors get this money from? So can the creditors turn to the members, those who own the company, particularly if the members are more or less influential persons, they are rich and wealthy? So can they turn to them and say, we know you have more than this amount even in your account? Now that is the incident of limited liability. So in that particular instance, for the member that paid 100,000 naira for the shares instead of the 200,000 naira, of course he will be asked to pay the remaining 100,000 naira. He is mandated to pay the remaining 100,000 naira. But the question is he mandated by law to pay beyond the 200,000 naira to satisfy the claim of the creditors? Of course not. That is the incident of limited liability. But I've explained this limited liability with respect to a company limited by shares. But for a company limited by guarantee, it is not like a company limited by shares. No, there is no shareholding contribution. So which means that in the company limited by guarantee, you are not expected to pay any money, you're not buying any shares. What you're just doing is that in the event that the company liquidates and the company is in debt, and you find that after the liquidation the company cannot pay up the debt, you are now saying that, okay, you have now made a commitment to pay so amount of money. So if it is a company that is limited by guarantee that liquidates and creditors are all over, they want their claims to be satisfied. Now once the company's assets, they look at it that, okay, the money that the company has, the company cannot discharge or defray its debts, then they will call up on the members, those who have made a commitment to contribute. But now, if I'd made a commitment to contribute, say 100,000 naira, but another person 100,000, and by the time we all make good our promises, so to say, you find out that what, when you join the money together, it still cannot satisfy all the claims of the creditors. Now the question is, can we be asked to pay more so as to ensure that the company is able to meet up with its debt, so to say? Now if it's a company limited, of course this is limited by guarantee. The law says we cannot pay beyond the amount that we promised that we're going to pay in the event the company liquidates and the company is in debt. So that is what limited liability means. It means that the liabilities of the members are tied or are limited to the extent of their contribution to the company. But suffice to quickly debunk two erroneous, or should I say two misconceptions that one way or the other I've seen being peddled in some quarters. And one of it is that while limited liability is an incident of incorporation, it should be appreciated that it will be wrong for you to then assert that the moment you incorporate a company, that company automatically becomes a limited liability company. No, incorporation does not give a company or the gerb of limited liability. It is the members, those setting up the company, that decide whether the company will be a limited liability company or not. And this is what I mean. When you incorporate a company, nothing says that it's automatically a limited liability company, because you can incorporate a company and say it should be an unlimited liability company. So you incorporating the company will be the one to decide whether the company should be a limited liability company or an unlimited company. And that is the reason you find that when you check section 27 sub 1 paragraph F of CAMA 2020, the provisions of section 27 are what we call conditions, that is those things that must be in the memorandum of association. And the memorandum of association pursuant to section 36 is a compulsory incorporation document, which means you must always file your memorandum before the commission will be able to register your company. So in section 27 sub 1 paragraph F, it says that one of the things you must state is whether the company is limited by shares, limited by guarantee, or is an unlimited company. So you see that it is those that are actually setting up the company that determines whether the company will be a limited company or an unlimited company. So it does not necessarily mean once you register a company, that's what gives the company a limited liability tag, so to say. Then the second misconception is, now when we're speaking of limited liability, please, it is important to understand that it is the interest of the members that is limited. The company has unlimited liability, so to say, and this is what I mean. Now, in the event that the company cannot satisfy the claims of the creditors and all, you find that all the assets of the company would more or less be put towards satisfying the claims of the creditors, meaning that the company, remember that the company being a separate legal entity, the company cannot say that my liability to them is limited to this extent. No, everything would go. It is only the members that can limit their own liability to say that, okay, well, after I have bought shares worth 1 million naira, and once I've paid 1 million naira, it does not matter whether the company itself cannot cannot pay outside as the creditors. I will not be required to pay more than this 1 million naira. So the members are the ones that actually enjoy limited liability, because the liability of the company itself is actually unlimited. And suffice to also bring to your attention that the concept of limited liability should not also be pushed to the hill. Should not also be pushed to the hill, because of course there are ways to circumvent it and go around it. And also it should be understood that particularly those in managerial positions, they may find out that despite the fact that they have a company limited, a limited liability company, there are ways that they may still be personally responsible while even acting on behalf of the company. Say for instance, where a tort has been committed, there's different machinery that can be used to do so, maybe through the doctrine of agency or the doctrine of identification in criminal law, particularly when you're talking about corporate culpability. The doctrine in criminal law, agency can also be used, taught, so that way they may still find themselves being liable personally even when acting on behalf of the company. But at any rate, this explains or this answers the question, what is a limited liability? And this leads me to the question, how does a company become a limited liability company? Perhaps I believe I've mentioned this in the course of attempting to provide an answer to the first question. A company becomes a limited liability company by way of its members, or those who set up the company, that is the incorporators, by way of them stating in the company, in their memo, that this company would be a company limited by shares or a company limited by guarantee. So which means it will be they will be the one to state it that it's a limited liability company. And you have to appreciate that, owing to the fact that creditors that would be dealing with a limited liability, they should know, or yes, they are expected to know by law, that when dealing with a limited liability company, it is at their own peril. It is at their own peril. They are like on your own. And this fact was also enunciated in the landmark case of Solomon and Solomon, and which is actually a case that typifies, or a case that represents the principle of corporate personality, but which I shall not delve into so much in today's analysis. What I'm saying is that the law says it is the members that determine whether a company would be a limited company, and you can see that pursuant to section 27(1) paragraph F of CAMA 2020. And also the law says that there should be a disclosure, or should I say what is otherwise known as warning of irresponsibility. Warning of irresponsibility, meaning that those that are setting up the company and they are deciding that this company is to be a limited liability company, they must disclose to the public that we will not be responsible for your dealings with the company beyond our contribution to the company. And that is the reason why the law says that when you're setting up a company that is either limited by shares or limited by guarantee, you must actually put it as part of the names of the company. And you see that CAMA also incorporates this corporate principle. Pursuant to section 29 of CAMA 2020, it says the name of a private company limited by shares shall end with the word limited. It said the same thing of a public company limited by shares ending with the words were public limited company. So there must be that limited there. It's a warning of irresponsibility. So we are not responsible beyond our contribution to the company. So once we have contributed and the company that you dealt with cannot satisfy your claim, you are on your own. You have been left in the lodge, except if you activate any of the exceptional machinery that you may use to circumvent what the harsh effects, so to say, of limited liability. So this is very, very important. And also it is important to state that the fact that a company is a limited company does not mean the limited there is supposed to connote a big size. No, a fact that a company is a limited company does not mean it's a big or company. PLC, public limited company, may suggest size. And then you understand that limited there is only a warning of irresponsibility, to say we're not responsible. And that is that as to how a company can become a limited company. And then we proceed to the third question, which is, what is the legal significance of a limited liability? Of course, the legal significance of limited liability, as I earlier noted, is that it means that the members have tried as much as possible to protect their interest in the company, and what they are doing is that they are setting up a business concern, and since they want to enjoy the incidence of a corporation, they are saying that the company is separate. So whoever it is that wants to deal with the company deals with the company as a separate entity from the members of the company. And they are now saying that, see, once we have contributed our own money, either by way of shareholding or by way of the guarantee that we have made, if the company is involved in any debt, any liability, then we cannot be held responsible beyond the amount that we have contributed or the amount that we have agreed to contribute. So that is the legal significance of limited liability. So which then means that people dealing with a limited liability company may have to watch out and find ways to protect themselves, because they may be left in the lodge, just as the unsecured creditors in the case of Solomon and Solomon were left in the lodge. And to their utter consternation, they realized, or they found that the trustee pitched his tent behind Aaron Solomon, which was something they more or less considered to be fraud. But of course, that is just the legal incidents of incorporation, corporate personality, and also the legal incidents of limited liability. Then to the next question, how can creditors protect themselves? Now this question becomes important and relevant in view of the fact that the concept or idea of limited liability may first discourage investors, creditors from relating with a company, transacting with a company. And aside that, it is also for the fact that the concept of limited liability may also do violence to creditors, because many a time we find that they contribute money to the company, and having contributed money to the company, now the company cannot satisfy their claim, and yet you have members of the company, those who ran the company aground, then claiming that they are not to be held responsible and all, and they may have made a whole lot of profit from the company. Of course, the machinery of company law is such that it tries as much as possible to protect creditors by way of maintenance of capital, saying that the company's capital should not be returned to the members, save certain exceptional circumstances. But at times you find that this may not be sufficient. So the company law also tries as much as possible to provide avenue that creditors may also activate by themselves. So the question is, how can creditors protect themselves? There are several ways creditors can protect themselves, but I shall be looking at just two ways. The first way to protect themselves is for the creditor to obtain a personal guarantee from a member of the company, and that personal guarantee will be on the personal assets of that particular member. So if you feel like, okay, you are dealing with a company limited by maybe shares or guarantee limited company, and you look at it that you are dealing with them at your own peril, so you want to protect your own interest. And so what you can do is look at it. If you find that there's anyone that is influential, anyone that is wealthy there, then you can say, okay, if you want me to deal with this company of yours, then you will give me a personal guarantee that in the event that this company as it is cannot satisfy my claim to the fullest extent, that I can run after your or look to your own personal assets. Then if it does that, then that means he's saying that it can indemnify you, that it will indemnify you. So it's a personal guarantee to indemnify you. And aside that, you can also activate another avenue which is somewhat similar to this, and that is provided by CAMA. You find it in section 314 and also section 315. So section 314 of CAMA says that in a limited company, the liability of the directors, managers, or managing director may, if so provided by the memorandum, be unlimited. So this deals with how you can introduce unlimitedness into a limited company. How you can introduce what? Unlimitedness into a limited company. So which means that you can have a limited liability company, and yet the liabilities of certain members may be unlimited, and that is what you can find in section 314. So if the company provides for it in its memorandum of association that the liabilities of the directors, liabilities of managing directors, managers would be unlimited, it's a way of enticing outsiders, creditors, investors from investing into the company. So if that is there, then of course you can always activate that to protect yourself, since you know that the liabilities of certain members are unlimited. Of course, this does not fully protect you, because the memorandum of association is an alterable document. It can be altered. So what if the memorandum is altered and their liabilities that were hitherto unlimited now become limited? Of course, you may want to ensure that that provision that makes the liabilities of these individuals become an entrenched provision in the memorandum of association, so that it will not be so easy to amend. But for entrenched provisions, that would constitute the subject matter of another analysis in another video. Then section 315 says a limited company, if so authorized by its articles, may by special resolution alter its memo so as to render unlimited the liability of its directors or managers. Of course, section 315 responds to the shortcomings or lacuna in section 314, because section 314 deals with a situation where from the early beginning, or before the creditors deal with the company already has it in place that the liabilities of the managers, directors, and all will become unlimited. But the question is, what if you are dealing with a company that does not have such a provision? Now 315 says they can also achieve the same thing as section 314 by then altering their resolution, altering their memorandum of association by way of a special resolution, and then stating it there that the liabilities of these individuals will become unlimited. So even if the company cannot satisfy your claims, you know that you have certain persons that you can run after, and when you run after them, they shall then pay you. Then another way is for you to, which I've already explained, to secure personal guarantee on the personal assets of the members of the company. And that is all that there is as far as this analysis is concerned. And I believe that by now you appreciate what limited liability means. And without wasting our time further, I would like to quickly introduce this study guide to you. This is the study pack on company law and essays on CAMA 2020, authored by Emanuela Astin and my humble self, Yusuf Oluwafemi Salako. And as you can see, some of the features, the topics are explained in a leisurely manner to ease comprehension. And the study pack also has the provisions of the company's regulations 2021, pari passu provisions of CAMA 2020, It also has provisions of the module articles. It explains key concepts, technical terms. It also has practice questions that you can use to evaluate yourself, and landmark cases like Salomon and Salomon, Hickman and Keynes. These cases are full, or Allen and Goodrich, they are fully reported. So it's a book that I feel and I believe would be of immense assistance to you, and it goes for 6,000 naira. Once you need it, what you just have to do is to reach out to us wherever you are in Nigeria. This book and I, Ori David, we are always with you. And till I see you next time, do not forget to continue to stay in love with company law. Stay jiggy.